Good afternoon, everyone. My name is Jeremy Herman, and I'm an employment lawyer with Samfiru Tumarkin LLP. It's great to be back with you guys. I've hosted a bunch of these question and answer sessions, and I always enjoy being able to spend some time with all of you and address all of your employment law legal questions. There's lots of important topics that we go through. And we try to get through as many questions as possible. Just to let everyone know, as I usually do, we have offices across the country, and particularly we have offices in Ontario, British Columbia, and Alberta, and I'm located in Toronto. Okay, so we're all over the map here in Canada to be able to help you with your employment law issues. So feel free to reach out to us. You can contact us, as you see on the screen, at helpinemploymentlawyer.ca. And you can start off by asking whatever questions you might have today during this question and answer session. Before we do get into topics, I want to talk about an important issue that people deal with all the time that I see in my legal practice as an employment lawyer. And that has to do with a stress leave. Many employees have to take a stress leave during the course of your employment, could be more than one. And it's important to know what your rights are in that regard. So in Ontario, it is a job protective leave under the legislation in Ontario that provides employees with their minimum entitlements. Okay. And that legislation is called the Employment Standards Act. And so that act does provide employees with sick time, and specifically they're entitled to 3 unpaid days of sick leave per year. Now, what's also important to note is that there are many employees who actually have a better policy than that, because their employer says, well, we won't only give you the minimum of 3 unpaid days that the law allows you to have, we'll actually top that up. We'll give you 5 days, for example, or maybe 7 or 10. And in some cases, those days are paid. So some employers will actually give more days, and some of them will even give more days and pay the employees for those sick days. And the employer might want certain documentation to show that you were in fact sick. But that is the basic right that employees have, those 3 unpaid days. And like I said, the employer might top it up. Important to note that you can't be terminated as a result of taking these unpaid days. And if you are, then you'll be owed your full severance pay. There's no doubt about that. But you might even be owed more money because your employer would potentially be discriminating against you, which is a breach of our human rights laws in Canada, for taking the sick leave. Perhaps you need to take a sick leave because you actually have a medical issue or a diagnosis that you have to address. And so if your employer knows about that, and in response to you wanting to take the sick leave, you get terminated, that's a major, major legal problem that your employer faces, and you will be owed compensation as a result. So that's very important to note with respect to sick leave. Just if you're facing any of these issues, you can check out all the resources we have on our website at employmentlawyer.ca. I discuss with people these kinds of problems almost every day, so feel free to reach out to me. You can contact us at helpinemploymentlawyer.ca, and we'll be sure to arrange a call with you and discuss your particular issue. Okay, so that's just a little bit about sick leave, and now we'll jump into questions from all of you. Okay, we have a question on Facebook from Jet. I'm receiving a settlement from a former employer that I left 1.5 years ago. I was surprised to learn that it'll be paid via direct deposit. While convenient, I didn't expect them to have my banking info on file. Are employers required to keep that kind of information for a certain period, like they are with other records? This doesn't really appear to be a major issue. Usually when there's a settlement, your employer will pay the settlement to you, and there could be various ways of paying the settlement to you. It just really depends on what you or your legal representative arranged with the company. It might be that they pay you by direct deposit. It could be that they pay the law firm, who then disperses the money to you. There could be various forms of payment. And that should be something, again, that's arranged between you and the company, or your legal counsel and the company. Okay, moving on. We have a question from Deer on YouTube. I'm a salaried employee making $50,000 a year. After providing a doctor's note to work remotely for the rest of my pregnancy, my employer reluctantly agreed, but is now switching me to hourly pay, claiming a material change in duties. My tasks haven't changed much, and I'm worried this will affect my income and return from my maternity leave. Is this a breach of contract, constructive dismissal, or discrimination under human rights law? So great question, and really the answer is that it could be all of these things. So let's step back for a minute, and we'll talk about the notion of a constructive dismissal. So a constructive dismissal is where your employer will change fundamental terms of your employment in a significant way without your consent. So in this case, we have a change in the mode of payment and the type of employee that Deer is, either an hourly employee or a salaried employee. Now that could very well have impact on the pay that this employee ultimately receives, and other things. So those changes would be significant, and as a result, if you did not provide consent to the employer to implement those changes, you can challenge them and say that it is a dismissal of your employment. And that is a constructive dismissal. A constructive dismissal could also be where your employer implements other types of changes to the terms of your employment that you have not consented to. For example, it could be changes to your hours. It could be changes to your duties, to your work location, and various other things that the employer cannot just do without you agreeing to it. You have to agree to these types of changes, and if you haven't and the employer forces them on you, then you can claim that you've been terminated, and you'll be owed your termination severance pay, just like anybody else who's terminated. Okay? So yes, in this case, it sounds as though there's a constructive dismissal. And again, this could even be discrimination if the reason why that they're implementing these changes is because of the fact that you're on a maternity leave, right? That's a protected ground under our human rights laws. You cannot be discriminated against for things like that. And so you would potentially be entitled to not only severance pay, but also damages or compensation because of the breach of human rights laws. Okay. One thing to note in this regard, and reverting back to the notion of a constructive dismissal, if you have a contract, an employment contract, and it says that the employer can implement certain changes to your employment, you've agreed to that, you've signed that contract, then the employer might be able to implement those changes. So what I see in my legal practice often is a term in a contract that says that the employer is able to implement changes to the employee's hours, for example. Okay, the contract might say you work 9 to 5, but subject to certain situations, the employer might be able to change the hours of your work, and you hereby agree that those changes may be implemented, and it would not be construed as a constructive dismissal. So if you've agreed to a term like that, then there's a bit of a legal problem with you challenging it if those hours are actually changed throughout the course of your employment because you signed a contract that says the employer can implement those changes. Okay. But for that to be in effect, the contract, again, has to be provided to you. It has to be signed. You have to understand the terms. It has to have been provided to you without any duress, so you weren't forced to sign a term like that. And then perhaps your employer can rely on that to implement certain changes to your employment. So that is a great question. And if you have a follow-up, please feel free to post it in the chat. I'm sure we'll talk about a constructive dismissal again throughout the course of this session. So thank you for starting us off. Again, for all of you who are just joining us, I am Jeremy Herman. I'm an employment lawyer with Samfiru Tumarkin LLP, located in Toronto, Ontario. And I'm here to answer all of your employment law questions. So don't be shy, post them in the chat, and I'll get to as many of them as I can. Okay, we have a question from Jerry on Facebook. Jerry says, I've been full-time since 2021 and was temporarily laid off 13 weeks ago. Today, they offered to bring me back in 2 weeks, but only part-time. Am I entitled to severance, and could this be a constructive dismissal? I told you that we would talk about a constructive dismissal again, so here we go. So starting off, if you are laid off, okay, temporarily, and your employer says we might recall you, that could be a constructive dismissal itself. You don't have to agree to be temporarily laid off. Okay, you can say, well, I didn't consent to you laying me off and letting me know when you'll bring me back to work. And so you've terminated my employment. And again, unless your contract does say that the employer can do it, then your employer can't do it. And there are sometimes contracts that do say that the employer can implement a temporary layoff and you agree to it. Okay. Now, either way, a temporary layoff could only last for a certain amount of time, even if it is not illegal, right? So even if the company has a contract that you signed that says that they can lay you off temporarily, they can't do that forever. They still could only do it if it's legal for a certain period of time. And that's typically going to be 13 weeks or 35 weeks. It depends on if you have certain benefits that are being continued during the temporary layoff. Okay. But going back to Jerry, if you did not agree to this layoff, it is a constructive dismissal. If now you're being told that you're going to be able to come back to work, but the employer is saying that it will only be part-time, then that is a significant change that we talked about earlier. It's a significant change to the terms of your employment. Your hours are reduced, therefore your pay is likely going to be reduced. And so you don't have to agree to that. And again, that would trigger a constructive dismissal, and it would trigger your entitlement to your severance pay. Absolutely. So if you have any hesitation, you shouldn't, Jerry, contact our firm at helpandemploymentlawyer.ca, and we will be sure to assist you. And for anyone else out there who's been temporarily laid off, don't think that that is a legal thing. It very well might be illegal, and we will be will definitely be able to help you in that regard. Okay, if you have any follow-up, Jerry, feel free to post it in the chat. Okay, we have a great question here, it looks like from Lindsay on YouTube. If I don't sign my severance agreement by the date listed, does that mean I'm no longer entitled to anything? How is severance different if I'm a federally regulated employee? Okay, well, let's start with the second part. Your severance entitlements don't really change if you're a federally regulated employee. There are maybe certain changes to your minimum entitlements, but that's not what we're talking about here. What we're really talking about here are your termination severance entitlements that have to do with certain factors. And those factors are your age, your length of service, your position that you held with the company, and generally speaking, the availability of similar employment opportunities for you and your based on your experience and your position in the job market. And so those are the factors that are relevant, whether you work for a bank that's federally regulated, another federally regulated employer, or a provincially regulated employer, like most of them. Those factors are the same. Okay, the severance entitlements are going to be based on your particular circumstances, your age, your position, your length of service, and what the job market's like for people like you. And so that's the second part. Lindsay, the first part, I read termination letters and severance agreements every day of my legal practice. And pretty much every single time there is a deadline that is listed in the letter, in the termination letter or severance agreement. And the employer will say usually that you're going to get a certain amount of money, but in order to get it, you got to sign back the letter by a certain date. And I see that some employers will provide 2 days, 3, 5, 10, 2 weeks. It really varies. It changes every time. Why does it change and vary? Because the employer is making it up. The employer is choosing what date they want to put in that letter. And the reason why they're doing that is simply to put pressure on you to accept the offer that they're making to you. They want you to accept whatever they say that they're willing to give you as a severance package. Okay. But the reality is that the deadline is completely arbitrary. Again, they've made it up. It could be extended. And even if it isn't extended, I'm not really worried about it because you're going to be entitled to your severance pay anyway. Is there a real deadline? Yeah, there is a real deadline. That's 2 years. Okay. You do have a deadline to pursue your severance entitlements. So if you're terminated today, September 4, 2025, you got 2 years from today to pursue your entitlements. Okay, so that's a hell of a lot of time, but we don't want you to take that much time. You don't want to take that much time because lots of things can change with respect to your employment. Maybe you'll get a new job. Maybe the employer will go bankrupt. There's no reason to wait to pursue your entitlements, but the deadline that the employer puts in the letter is not a real deadline. Okay, what I usually recommend to people is you can ask for an extension. If the employer provides an extension, great. And if they don't, as I mentioned before, I'm not particularly worried about it. Usually when I get involved to negotiate severance packages for employees who've been terminated, I'm getting involved after the deadline in the termination letter, almost always. So again, the deadline does not really mean anything at all. Okay, Lindsay, I hope that helps. And if you do have a severance agreement, I'd be happy to review it. Please contact us. If you want, you can ask for me particularly to review it, or someone else from my team would be happy to do so as well. So let us know, help@employmentlawyer.ca. Don't hesitate. Contact us right now. Okay. Let's see what else we got here. We got a question on YouTube from Shane. I work a day rate type of job, and I have for 15 years. Just recently, my employer has sent out an email stating they are changing our wage pay structure to a percentage base at a rate that pays 20% less. Okay, so Shane, that's not good news. That's probably illegal. So if your employer paid you a certain wage and now you're being informed that you're going to get 20% less, and it could be an actual 20% pay cut directly, or the wage structure has changed in a certain way that would ultimately result in you obtaining 20% less income per year. Either way, that's illegal. Your employer can't do that. That is a significant change. We're not talking about 2, 3, 5, 10%. We're talking about 20%. And so that is a big percentage. And, if you're earning, for example, $100,000 a year, 20% pay cut means you're going all the way down to $80,000 a year. It's not a small amount of money. And so this would be a great example of what we've been talking about, a constructive dismissal. Your employer cannot just change your wage or your pay structure without your consent. Maybe there's an employment agreement, Shane, that you signed when you started working for the company or at some time after you started working there that allows the employer to change the pay structure. But don't necessarily think that even if there is that kind of language in the agreement that the employer can in fact change your pay structure. Could be that the agreement is improper, invalid, and therefore the employer would not be able to implement these kinds of major pay structure changes. So let us know. Arrange a consultation with us, help@employmentlawyer.ca. We will look at the email that you were sent, of course, that notified you that there's going to be this pay change. And we'll ask you for other documentation that's relevant, including your employment contract, if you have one, so that we can see whether there is, in fact, language that would permit your employer to implement this change, but I doubt it's going to be a problem. Okay, great question, Shane. I hope that satisfies you. And please, if you have a follow-up, post it in the chat. I'll try to get to it. Isabel, you've noted that you're unionized. So unfortunately, I can't really help you if you're unionized. You got to grieve any issues with your employment through the union. Okay, there's going to be a union process that you can go through in order to address any issues you might have. Okay. Shay, we have a question on YouTube from Shay. My employer automatically deposited the amount they said I was owed for severance. They didn't have me sign anything, and I think I'm owed more. How do I show they didn't accept the payment? Don't worry about the fact that you received the payment, so long as you haven't actually signed a termination letter or settlement agreement or severance agreement. Could be called various things, but if you sign something, then you might be out of luck. We can look at it. But if you haven't signed anything and your employer just came along and gave you a termination letter, told you they're going to pay you $5,000, for example, and you didn't sign anything and the employer dropped it into your account, doesn't mean you're not entitled to more. Does not mean you can't negotiate. It doesn't mean that you have given up any of those rights. Okay. Usually what's happening here is the employer is depositing a minimum amount of termination pay that they have to give you. So I alluded to this earlier when I was answering a question. There are certain entitlements that employees have in Ontario that are mandatory. They get them upon termination no matter what. They don't have to sign anything. The employer has to give them. Usually, that's what the employer is going to just drop into your account after termination. That could be things like accrued vacation pay, minimum pay in lieu of notice, which is usually a week per year. You get 1 week of pay per year of service, up to 8 weeks. It could be things like that. It usually is that you're being provided. And then maybe the termination letter said, in addition to those things, we're going to give you another $5,000. So that $5,000 you do have to sign in order to get that amount of money. And that is the part that typically the employer will withhold until you actually sign documentation. And then your employer will give you that amount of money or any amount that you've negotiated. So Shay, don't worry about it. Contact us and we can definitely help you. If you think you're owed more, you're probably right. And we'll be in touch with you as soon as possible. You should contact us now. There's really nothing stopping you. help@employmentlawyer.ca or go to our website, employmentlawyer.ca, find our number, call us. You can ask to speak with me if you wish, and I'll be sure to assist you with letting you know if you're owed more severance and going after that severance for you. Okay, before we move on, I want to talk about something very important. A lot of what we discuss in these question and answer sessions has to do with severance pay, right? It's a key right that employees have in Ontario. It's an entitlement that happens when an employee has been terminated. And so lots of what we deal with as employment lawyers is severance pay and helping people obtain it. So we talk about that in these question and answer sessions a fair bit. We get lots of questions about it. And so it's an appropriate time to tell you that you should check out our website. We have a website called Pocket Employment Lawyer. And the Pocket Employment Lawyer will allow you to figure out how much severance you're owed. So you see it on the screen here, pocketemploymentlawyer.ca. Use that tool. There's a severance pay calculator as part of the Pocket Employment Lawyer tool. And that severance pay calculator, you should know, is free. It's anonymous. You can use it as many times as you want. You can tell your friends and family about it. They can use it too. And the point of it is for you to find out how much severance pay you are owed if you're terminated. Maybe you've already been terminated. Shay, you said that you've been terminated. Why don't you check out our Pocket Employment Lawyer tool, figure out how much severance you would be owed, and then I could help you get that. If you haven't yet been terminated, but you think maybe a termination's coming down the pipeline, things aren't going so well at your job, so you want to figure out what your severance entitlements are so you are ready to pursue them if you are in fact terminated, check out our Pocket Employment Lawyer tool and the severance pay calculator as part of that. It's a great tool, like I said, free and anonymous, and it will ask you basic questions. What is your age? How long did you work for the company? How much money did you earn? What position did you have? Things like that. It takes about 2 minutes to complete, and then it will tell you what kind of entitlement for severance you have. All right. So everybody, make sure that you check that out, and hopefully it will be helpful. Okay, we have time for a little bit more. So let me answer a question on YouTube from Cobble. I was laid off in May and didn't sign the severance package by the July deadline because I was still processing everything. I've experienced bullying and gaslighting at work. Now I'd like to negotiate the package. Is it too late to sign or negotiate now? No, it's not too late. I'm going to presume that when you say May, that you're talking about, let's say, May of this year, May of 2025. They wanted you to sign by July 2025, and you haven't, and you can definitely still negotiate then. Like I said earlier, you have in Ontario 2 years to pursue your severance entitlements. Okay, so July is not a real deadline. It could have been June. It could have been September. It could have been May. The point is that you have 2 years. Now, don't wait. You want to pursue your entitlements as soon as possible. It's an entitlement you have, so you shouldn't wait on it. But it doesn't mean that you've given it up if now it's September time and you were terminated in May and you haven't signed or negotiated anything. Okay, so we'd be happy to help you with that. Again, contact us at helpandemploymentlawyer.ca, and we'll be sure to arrange a consultation with you. Look at your documentation. We want to see your termination letter, your employment contract if you had one, maybe some T4 statements, pay stubs, and things like that. Okay, so that was a great question and answer session. I got to all the questions, I believe. If there are any others, feel free to join us tomorrow. We have another question and answer session at 1 p.m. with my colleague Lior Samfiru. So tune in for that, and I will be back with you soon for another session. Thanks again, and take care. Have a great rest of your day.